Welcome back, students. Yes, before starting next topic, now some candidate who has qualified Haryana main examination has come here and we conducted interview also in court. Now I want to bring her before you also. Some students who may be online, they may also ask some question. They may also conduct interview while sitting at home. In other words, we can say, yes, Srishti, come here. Take this mic. Now, Srishti, you introduce yourself to them from where you have done your law and which exam you have qualified.
My name is Srishti Lamba. I am from Jalandhar city. I completed my LLB from KCL Institute of Laws Jalandhar in the year 2018 and I appeared for Haryana Judicial Services and I qualified the mains examination.
All right. All right. Now we conducted today interview. She gave very nice replies. All right, students. Now Punjab government, it is going to advertise the posts because it has been decided that only High Court will conduct the exam. Public Service Commission will be out of the purview of this exam. It means that you are to submit your application to the High Court only. It will be High Court which will be conducting the exam. And very shortly, maybe within a week, the posts will be advertised and you will be given an opportunity to appear there. Now, one student, now here, Shreya, she has asked one question, that how they should prepare for preliminary exam in Punjab. Let us hear Srishti. Yes.
As far as preliminary exam is concerned, I can assure you that you only need three things: your bare act, your notes which you prepare in the class, and your test papers. And I can give you in writing that 70 to 80% of your exams, the law portion of your exam, will be out of these test papers. I have appeared for prelims twice, and I have myself seen that 70 to 80% of the exam is going to be out of these exams. The language may be changed, the options may be molded a bit, but the questions are going to be these only.
Yes, no, very good. She has pointed out because I have asked you people to maintain the copies and you are having that copy. I have dictated whatever is required under any section. You should not go to any other book. You may not go to any textbook. You have to read that your own copy, which has been prepared by you, and with the act, no doubt. Whatever the question tests, question papers have been given to you, go through those also. Yes, any further? Harman? All right, online.
Good afternoon, sir. Supriya
Yes,
Jain.
Priya, she is coming before talking me. Yes, Priya,
Yes, sir.
do
Sir,
you
my
want to
question
ask any
is,
question?
yes, sir.
Ask that.
Ma'am, please explain in contracted voidable contract or voidable contract. Difference between both. Difference between voidable contract and voidable contract.
Yes, voidable contract and void contract.
A void contract.
Now she is conducting interview online.
Yes. A void contract is a contract which is void and it is no contract in the eyes of law. However, a voidable contract is the one which is a contract, it is legal contract, but it is voidable at the option of a party to the contract. As long as it is not got annulled or cancelled by the decree of the court, the contract will be deemed to be valid and it will go on. But a void contract is simply void and it cannot be enforced in any manner.
All right. Sapriya, very good. You are asking this question.
Yes, ma'am. Article 32 and Article 26 of Constitution. Please explain.
226, you want to say?
Yes, sir. And 32.
Yes. All right. Let us see. Now 32 article and article 226. I hope she will be able to give a reply. Yes.
both the Article 32 and 226 of the Constitution, they deal with the writ jurisdiction of Honorable Supreme Court and Honorable High Courts. The difference between both the articles is that as far as writ jurisdiction of High Courts is concerned, it is much wider than the power of Supreme Court. Honorable Supreme Court can issue writs only for the purposes of enforcing fundamental rights, but as far as High Courts are concerned, they can issue writs not only for the enforcement of fundamental rights, but also for other purposes.
Very good. Very good. So, Priya, next question.
Please explain, ma'am, section 34 and 149 IPC and with section 120B.
Yes, 120. She want to ask some. Section 34, common intention, 149, common object, and this section 120B, criminal conspiracy.
Section 34 deals with common intention, that more than one person have participated and in commission of the offense in furtherance of common intention. The main element of section 34 is that some form of participation must be there. The participation may be overt or it may be covert. And it has been clearly held by Honorable Supreme Court that even the presence of the person on the site of offense will be deemed to be participation. But under section 149, it deals with common object. In prosecution of common object, the offense has been committed. Here, it is not essential that all the persons should have participated directly or indirectly. Merely being a member of unlawful assembly is sufficient for conviction under 149. And the main difference is that under 149, there must be at least 5 members in the unlawful assembly, but there is no such condition for common object under section 34. And as far as criminal conspiracy is concerned, under section 120, criminal conspiracy is the agreement to do an illegal act or an act which is not illegal in itself, but the same has been agreed to be done by illegal means. So in criminal conspiracy also, there should be at least 2 persons, because one person cannot conspire with himself, and 2 persons must have criminal conspiracy. It's itself an independent offense, even if the offense has been committed or not, even if no act has been done in furtherance of the conspiracy. But if there is an agreement to do an illegal act, it is punishable by itself.
Very good. Very good. She has replied nicely. Now, when she was getting training from here in the class, she also used to ask multiple questions. And she was also actively participating at that time to come on the stage. That is why I ask you people also, whenever you are having opportunity, come here and to narrate something. Yes, Priya, you want to say something else?
Yes, ma'am. Yes, sir. Ma'am, what is a substantive law and how it is different from procedural law?
Yes.
Substantive law is the law which tells us what the rights of a person are or what are the offenses which are punishable. But procedural law is the law which tells us how the substantive law is to be implemented. So substantive law deals with the rights and liabilities, and procedural law provides the procedure which has to be adopted by the court of law in implementing the law.
Yes, Ashok, others too. Who is other? Yes, Sagar. Bring Sagar now. Yes, Sagar.
Yes, good afternoon, sir.
Good afternoon, Sagar. Do you want to get some information from her, because you are also going to appear in Punjab? Yes. Do you have any query?
No, sir.
All right. All right.
Sir, मैं पूछना है कुछ.
We are feeling as if you are present in the class. All right. Ask that also.
Who is judge?
Supriya will also become a judge on one day. Now let her hear over that who is judge.
Section 19 of Indian Penal Code provides that a judge is a person who is empowered to give a definitive judgment or a judgment which is capable of being definitive. So even if a person is a magistrate, it does not necessarily mean that he is a judge. A magistrate will be a judge only when he is empowered to give a definitive judgment in the matter before him.
Very good. Very good.
Ma'am, can local commissioner is a public servant?
A local commissioner is appointed by the court, so he is a public servant.
मैं एक क्वेश्चन लिखा सर ने बैक स्क्रीन पे, प्लीज ਉਹਨੂੰ एक्सप्लेन कर दो. मेरा लास्ट क्वेश्चन है.
Define public servant elaborately. and discuss the difference between. Yes, Supriya, we have already asked this question and we
Okay, sir.
discussed that. I think now we should also conclude. Any student who is sitting in front of me who want to ask. Yes, Abhishek, Javin, any question because you have to prepare Shiny? Rajinder? All right, Srishti. We wish that you must come in this, become topper of that.
All the best, ma'am.
Thank you. Thank you.
All right, do this. All right, students, we will now watch next lecture. Thank you.